What Lord Denning attempts to do in Davis and Johnson is to add a new rule, is to liberalise, if you like, is to open up the law on this point and argue that there is another occasion when the Court of Appeal could choose to depart from one of its previous rulings. And the case here is Davis and Johnson. Let me tell you a little bit about this case. It concerned domestic violence. The Court of Appeal was considering the case of a victim of domestic violence. Miss Davis had unsuccessfully asked the court for an order to compel her abusive partner to leave the flat that they had been sharing. To allow her appeal, to grant her the injunction, the Court of Appeal would have to depart from previous decisions where injunctions had not been awarded in similar situations. Now, this case has always, it's always impressed me. What Lord Denning is trying to do in Davis and Johnson has always impressed me. Clearly, we have here a set of facts which suggest that an urgent decision is necessary, that a woman requires an injunction in some fairly compelling situations, a fairly compelling situation. However, for the Court of Appeal to grant this injunction, it would need to depart from its own previous decisions. Obviously, this doesn't fall within one of the categories defined by Bristol Aeroplane. And what Lord Denning is trying to do here, I think, is to make an argument that the requirement, the urgent demand of justice, if you like, the requirement of justice, on these facts, in this situation, would justify the Court of Appeal departing from its previous rulings in order to provide this woman with an injunction. So what argument can Lord Denning use to justify this? It's a rather technical argument. I can't go into all the details, but I'll try and give you at least some of them. An argument from principle. Remember, the argument in Schorschmeyer was an argument from principle as well. I'm not going to try and summarise that Latin thing again because it reveals horribly my inability to pronounce the words. So anyway, let's think about the argument from principle in Davis and Johnson. Lord Denning began in Davis and Johnson by admitting that in normal circumstances, the Court of Appeal was indeed bound by its own previous decisions. He went on to criticise the consequences of this argument. It may, for instance, be that an appeal is never made to the House of Lords, or there is a long delay before the House of Lords has an opportunity to overturn the incorrect decision. It may also be that an individual lacks the financial means to bring an appeal to the House of Lords. This problem is compounded by the fact that wealthy litigants can pay off appellants and so perpetuate an erroneous decision in law. Moreover, in the present case, the delay that an appeal would cause would add to Miss Davis's hardship. Lord Denning notes that she was, whilst the case was being decided, resident in a battered women's refuge in appallingly overcrowded conditions. This is a quote from Lord Denning, quote, "In order to avoid all the delay and the injustice consequent upon it, it seems to me that this court, being convinced that the two previous decisions were wrong, should have the power to correct them and give these women, or Miss Davis in this case, the protection which Parliament intended they should have." I think this is a compelling case for the avoidance of delay. However, what are the consequences of allowing the Court of Appeal to overrule itself? Would the lower courts be left in confusion? For instance, a judge in a county court would not know which Court of Appeal case stated the correct law. Lord Denning argues that the lower court would simply follow the later decision, based on the principle that as long as the latter case contained a full consideration of the earlier cases, it was the preferable authority. I think this argument, Lord Denning's argument, is a variation on the argument that he's trying to make in the early case, Schorschmeyer. In other words, it's an argument about the tension between procedural principles and individual injustice, or the need to do justice in an individual case. The trouble is, I don't think either of these sides of these arguments necessarily play the other side off the field. Clearly, there is an important argument to say that in nearly all cases, the courts have to follow the hierarchy, because otherwise there will be chaos, and chaos will produce injustice. However, the counter-argument is that there may be exceptional circumstances, or circumstances where rights have to be protected or articulated, that would justify this departure from a settled rule. So it's a variation of the argument that Lord Denning made in the Schorsch-Meyer case. But in the Davis and Johnson case, he is engaging with a different set of legal issues. Let me just try and summarise these for you, because it takes us back to Young and Bristol Aeroplane. This is the case that's binding on Lord Denning. In other words, it's the one that limits the occasions when the Court of Appeal can depart from its previous rulings. So in other words, how can Lord Denning get round this case? How can he create an argument that gets round Bristol Aeroplane, in other words, allows him to do what he wants to do, which is to award this injunction to Miss Davis? What he argues is that the earlier case, the Bristol Aeroplane case, was not an accurate statement of the law. His argument returns to the roots of the jurisdiction of the Court of Appeal. When the court was set up in 1873, it was the final appellate court, as the jurisdiction of the House of Lords was not established until 1875. The court inherited, this is Lord Denning's argument, the jurisdiction of the Exchequer Chamber and the Court of Appeal in Chancery. As these courts were always considered to have the power to review their own decisions, it would be fair to assume that the modern Court of Appeal had inherited this jurisdiction. Lord Denning's argument also returns to another case, Hutton and Bright, which held, quote, that every court of justice possesses an inherent power to correct an error into which it had fallen. What conclusion can we draw from these cases? As Lord Denning succinctly put it, Young and Bristol Aeroplane, quote, overruled the practice of a century. The Court of Appeal is not, as a matter of law, bound to follow its previous decisions. It does so as a matter of what Lord Denning called judicial comity. Lord Denning thus argued that the 1966 practice statement effectively overturns the London Tramways case, and he concludes, quote, a rule as to precedent, which any court lays down for itself, is not a rule of law at all. It is simply a practice, or usage, laid down by the court itself for its own guidance, and, as such, the successors of the court can alter that practice, or amend it, or set up other guidelines, just as the House of Lords did in 1966. We are compelled to the conclusion that the Court of Appeal can follow the 1966 practice statement and depart from its own decisions if it considers them wrongly decided. Now, it seems to me a compelling argument. The trouble is, they were not ultimately successful. The conventional form of the doctrine of precedent in relation to the Court of Appeal, i.e. the rejection of Lord Denning's argument, was asserted by the House of Lords in Davis and Johnson. They knocked down Lord Denning's arguments. I haven't got the time to summarise the arguments of the Court of Appeal. Lord Diplock in the House of Lords preferred or argued that the House of Lords should reaffirm expressly, unequivocally and unanimously the rule in Bristol Aeroplane Company. In other words, we can say that Davis and Johnson was an unsuccessful attempt to change the way in which the hierarchy of the courts operated. In other words, Lord Denning's argument that precedent is about judicial comity were not accepted. What we are affirming here is a rigid hierarchy of courts. In other words, we are privileging the argument that justice requires coherent development of law, which in turn requires the courts to stick to their places in the hierarchy, and we are rejecting the idea put forward possibly by Lord Denning, that the unique facts of Davis and Johnson would have justified the Court of Appeal departing from its own previous rulings.